2 points of clarification. First, to answer your question, federal, but it also calls for the application of the commercial arbitration rules, not the consumer arbitration rules. So I think there's another threshold issue that we have to deal with.
That has already been determined by the arbitration board.
Right, I was just gonna, folks, this isn't the first time that this issue's come up, okay? Ms. Delvalle, has the AAA assigned this as a consumer arbitration?
That is correct. They have assigned it as a consumer arbitration, and we have objected to that.
That was Mr. Barnett answering for Ms. Delvalle?
Yes, sorry, I should have identified myself. This is Mr. Barnett. The AAA, without consultation to us, decided to apply the the consumer arbitration rules. And when we figured out that they made that decision without input, we objected to it, and they said that's what we're going to apply for now, but it's up to the arbitrator. And there is a specific provision within the terms of service that identifies the AAA's commercial arbitration rules. So we believe that that's a threshold issue that you need to determine.
Okay.
Let me know if I can make a comment, please.
Go right ahead, Mr. Crossett.
This arbitration process had gone on for months before Mr. Barnett figured out that it was consumer rather than commercial. He made a request for his money back. He made a request to move it to commercial, and commercial arbitration for me would lock me out financially. The fees, the sharing of the fees, all of those things would basically put my case in a fatal situation. The arbitration board said basically, in my memory of it, is that he waived his right. He should have found that the first few days. He didn't. He went in several months and he did not identify that. And I have moved forward with consumer arbitration ever since that point. And to have it reversed at this time would put my case fatal. I could not go with commercial.
Ms. Delvalle, can you hear me?
I can hear you, yes.
No. No man should answer this question. Katrina, can you hear me? Okay.
Yes, arbitrator.
I'm looking in the documents. Is there and again, I understand you may be stepping in here. So, is there a determination by the AAA as to the proper assignment of this case, or is there a determination by the AAA that defers to me to determine the appropriate AAA rules? And let me while you're, if you don't know the answer to that question real quickly, I'll ask the parties, but I just thought you might know.
The AAA determined it would be commercial, consumer, my apologies. The AAA determined it would be consumer rules and be left for determination by the arbitrator once one is appointed.
Okay, and that's what I thought would probably happen. So Mr. Barnett has it correct. So here's what we're going to do about that. Going to do a lot of briefing here. Okay, I'm going to Mr. Cross, you have the burden on your argument that the case is not subject to arbitrability, and that will not turn. Unless you all show me something that otherwise, I don't have any reason to believe that will turn on whether it's subject to the consumer or commercial rules. So you're going to stick with August 19th, up to 7 pages, not including exhibits, on the question of arbitrability. Mr. Barnett, when you make your response on 9-2, you're going to have 10 pages in which you're going to address the opposition to Mr. Crossett's argument against arbitrability, and also which rules should apply. Do you, hopefully you're going to tell me, Mr. Barnett, that within 10 pages you can address both those issues.
Yeah, I can do those both within 10 pages.
Okay.
Yeah.
Mr. Crossett, I'm going to add 2 more pages to your reply, that is 5 pages, in which you'll have a chance to reply to the question of arbitrability, and at that point you will respond to Mr. Barnett's arguments about which rules apply. Do you understand, Mr. Crossett?
I understand what you're saying. I'm thinking again. I thought this issue had been decided. It seems to be being redone, rehashed, and I'm not sure why. Maybe someone could explain that to me. The arbitration board made a decision. I've stuck with it. I've centered my case all around the consumer rules and regulations. I do not understand why we're rehashing this again.
Well, I don't know anything about rehashing, but the answer was given to us by the case manager. And by the way, it's very common, actually. When there's a dispute as to which rules apply, the AAA will make an initial assignment, and then if the party claims that it's assigned to the wrong set of rules, then the wrong set of rules are being applied, then the parties are permitted the opportunity to bring that question to the arbitrator, which is what Ms. Delvine said has happened, and I will say, in my experience, is quite common. So, you are correct to say, as Ms. Delvine has told us, that there was an initial determination by the AAA administratively to treat this as a consumer arbitration, subject to the arbitrator making a determination if any party claimed it was misassigned. So that's what we're doing. All right. Now, Mr. Barnett, do you believe you will need time to reply to Mr. Crossett's argument regarding the applicable rule only?
Yes, I do. I would like an additional, it can be a week or 2 weeks, either one, and I'd just like 2 or 3 pages, probably with headings, I think maybe 3 pages in the paper amount to be able to respond to Mr. Crossett's arguments regarding which rules should apply.
Okay, 9/23 will be your deadline for that. Surely 1 week is adequate to address the question.
That's fine.
If you have 3 pages, you're welcome to, and then by 9:30, I will give you a decision. Okay. I'll give you a decision on both. First, I'll decide arbitrability. Obviously, if I find no arbitrability, we don't need to worry about what rules apply.
Right.
If I determine that any claims are arbitrable, I will tell you what rules should apply. Okay. All right. So we said the FAA applies. That's the arbitration law. Is there, Mr. Barnett, a identification of applicable law as to any state law claim?
I believe it's West, yes, I believe it's West Arizona, to the extent that we're dealing with state law.
Did you say Arizona?
I did.
Okay. Mr. Crossett, as we sit here right now, do you have any reason to believe that some other state law besides Arizona is identified as the controlling state law?
Yes. Since the
What state law do you believe?
California state law, their current terms and conditions are in the Ninth Circuit, California state law.
Okay. We're going to resolve this right now. Mr. Barnett, in the federal district court, did Turo file the arbitration agreement?
Yes.
Okay. Can you tell me the docket?
I will find it, but I believe it's going to be our opening brief. Just scanning the docket right now. I believe it's It's in docket 28, I believe. And for speaking up, I think she's located it as Exhibit E.
Okay. By the way, Ms. Merrill certainly wants to know.
Thank you.
So I will tell you, docket entry 28 only has 3 exhibits. One is declaration of Roy Shaham. 2 is fast track rules and procedures, and 3 is AAA commercial arbitration.
The declaration has a bunch of exhibits attached to that, so if you scroll down, yeah, you'll see exhibit E on page 36.
Do you think it's exhibit E to Mr. Shaham?
Correct.
Declaration? Okay, stand by. Exhibit E. It looks like
It's not.
this on our recording. If anybody has any questions. Exhibit E is document 28-1 of 57, page ID 91, page 18 of that document entry. And then if I go down here, I'll find. Do you want to tell me where it is, Ms. Merrill?
Yeah, so it's on, under the terms, it's page 22 of 32, or in the whole PDF, it's page 58, and the first heading on that page says applicable law, and it states Federal Arbitration Act, and then to the extent state law is applicable, the parties agree that the substantive law of the state of Arizona will apply.
Okay, Mr. Crossett, I've just read along with exactly what Ms. Merrill just said. So if the case it remains in arbitration, any state law claims will be resolved under Arizona law. Okay, moving along. All right, if I give you a decision by September 30th as to arbitrability and the appropriate rules, you all will engage in an exchange of information which will be consistent with Rule 26A1A of both, it happens to be both federal rules and the state of Utah rules of civil procedure generally. But we're going to use, it'll be consistent with the federal rules of civil procedure. You're going to make disclosures under 26A1A, and I'm going to tell you, Mr. Crossett, what those are. You're going to identify to each other the name, address, telephone number, and email address of any potential witness with a brief summary of what you think that person knows that's germane to a claim or defense in the case. You are going to send, as opposed to identify, which is what the federal rule says, you are actually going to send to the other party all the documents that you're aware of that you think support any claim or defense in the case. You should come up with some numbering scheme. You can use a computerized numbering system. You can use something that stamps them. You can use a crayon in the lower right-hand corner or in the middle, but every document should have a number, because later it just really helps when we say we're looking at document number, page whatever. And for Mr. Crossett, you are going to identify each element of damage that you're claiming, the amount of money that you're claiming for each element of damage, and generally the manner in which you have calculated those damages. So if you say, do money because they promised to make me happy, I'm not happy, happiness costs this amount of money per day, and multiply that by the number of days, and I'm making this up obviously, but you're going to lay out basically your means of identifying both the element of damage and how you calculate the damages. They don't have to agree with it, you're just going to tell them what it is. Okay. And nobody needs to disclose the existence or amount of insurance, which is the other thing under 26A1A. All right. Mr. Crossett, first of all, do you understand what you're going to send to Truro?
I understand what you said. What I need to do is respond. Did you get my only deposition request?
We're not on depositions yet.
Okay, but in answer to who the witnesses are going to be, you're asking me to congregate the witnesses and what they're likely to testify to. Isn't that what you're asking?
That is one of the things you're going to tell them that of what you know at the beginning of the case. You're not limited to those witnesses. But if you know of a witness that you already know is going to testify in this case, you're going to identify that person or those people.
Okay, let me respond if I could, please. Basically, sorry, I don't mean to use the word basically. The fact of the matter is, my termination from Toro has no details, no explanation, no names. They use, quote, their discretion and their contract and dismiss me without notice, without investigation, and all I've asked for is for Toro to have one representative identify the facts of the case so that I can at least defend the facts of the case, because I have no facts of the case. They basically terminated me instantly with absolutely no notice. When we tried to get information, they stonewalled us. We don't know why we were fired, why we were terminated arbitrarily and capriciously. So I only need one witness, and Toro is very welcome to choose that witness themselves, and that is a person who understands the case and has the information. Then I'd be very happy to go forward. But how can I go forward when I don't have any information about why I was fired, who fired me, what the reasons were? I have none of that information.
I apologize if I wasn't clear, Mr. Crossan. You're going to testify in this case, right?
Yes.
Okay. So one person you're going to disclose is Mr. Crossan. And you're going to say, here's how you reach Mr. Crossan, and here's generally Mr. Crossan's going to testify. You may not know the name of any other potential witness, or you may, I don't know. But if you do know the name of any other potential witness, you're going to tell Turo who that is and how to contact them. Do you understand?
I'm thinking. I think I heard you just say, and correct me please if I'm wrong, that if I only know my own witness and my own address, I would submit one thing, just me. That would be sufficient according to your statement.
If you're only aware of yourself as a witness right now, then that's who you will list. But it'd be easier to explain it in the contract, which is you told us you have a person who helps you, and you know that person's name, you know how to contact them. If that person had information about any of your claims in this case, I'm not saying they do, but I'm just using them as an example. If they had information about claims in this case, you would need to tell Mr. Barnett that person might have information about claims in this or defenses in this case. If you don't tell Mr. Barnett that, and later we go to a hearing and you want to call that person,
I'm
you're
barred.
not going to be allowed to.
Right, I'm barred. Right, I understand that.
Barnett's going to say, wait a minute, I never knew about that person. Okay, so I think we understand that. So now, if I rule, you could start pulling these things together, because you probably would need them if you're in court as well. So if I rule on 9/30, whether we're going to arbitrate the case and how much we're going to arbitrate and what rules will apply, then I'm going to set as a deadline for you to make your disclosures, so we keep things going here, because we're already into September. I'm going to make the deadline for your disclosures September 9th. Do you understand?
Yes, sir.
Okay. Mr. Barnett, that's your deadline as well. September 9th. Okay.
So just so that I'm clear, and forgive me for repeats, you're choosing to have a disclosure deadline in advance of the completion of briefing on this on the issue of arbitrability and the applicable rules.
No, I really appreciate your pointing out that I was looking at the wrong date on the calendar. I meant October 9th. Thank you. You're correct. October 9th will be the deadline for disclosures. Okay, so that's the deadline for disclosures. Now, before we do anything else, if we know October 9th, so we're going to start discovery on October 9th with disclosures. No one should send anybody any other discovery request until they see the disclosures. The reason for that, Mr. Crossett and Mr. Barnett and Ms. Merrill, is because you may not need to do the same discovery once you see disclosures. Okay, don't do any discovery before disclosures. Don't request any discovery. And then October 9th, you're going to exchange disclosures. Now, Mr. Crossett, Mr. Barnett, and Ms. Merrill know this as lawyers. You may know this as well. You have an obligation to update your disclosures if you find that they're missing something. So if you identify a witness somewhere along the way, you got to send them a supplement each side. If you find a document that you didn't send originally, that you realize, oh gosh, I should have sent this back on October 9th, you need to supplement that as well. Do you understand that, Mr. Crossett?
Yes, sir.
Okay. Mr. Barnett, I assume you understand that?
I do, thank you.
Okay, super. Timely supplementation is important. Again, no party is going to be able to use a witness or a document that is not timely disclosed except for good cause shown. All right. Now, if you do disclosures on October 9th, I want to jump ahead. When, Mr. Crossett, do you think that you will have done all the things that you need to do so we can have a final hearing in this case to decide the merits of the case if that remains necessary?
Well, I can't answer that question until I find out what your rules and regulations are going to be on discovery. I need to do a lot of discovery. Like I said, I have no information from Toro at all on what's going on, and I need to have that disclosed to be able to be reasonable for me to defend myself. So maybe, I guess I'm asking you, I know that discovery can be limited to arbitration, but am I able to do interrogatories and requests for admissions? What are you going to allow me to do for discovery, please?
We're going to talk about what discovery you can do, but assuming for the moment that you had unlimited discovery, and you could send interrogatories, requests for admissions, requests for production, and you could take depositions, how much time do you think you're going to need to do those things?
I'm thinking, because the depositions are very, very timely consuming. I would need at least 3 weeks, not only to receive the documents and to do depositions, but to analyze them and then respond.
Understand. Mr. Barnett, how much time do you think you'll need for discovery?
I mean, the nature of discovery, if we're sending requests and getting responses and identifying witnesses and going back and forth, if we're doing a written discovery process and as well as possibly depositions, I think that's going to take a few months at a minimum to get through the time constraints involved in the sequencing. So I would,
Right, I'm
I would
thinking
think
3 months. I'm
What's
thinking
that?
3 months. 3 months.
Yeah, 3 to 4 months,
More than that.
I would say.
3 months should be more than adequate, because we're going to talk about some time-saving efforts here. The goal of arbitration is to get you all a relatively quick decision, and we've got some things we got to take care of, sure, but the goal here is to try to save time and money for everybody and get you a relatively quick decision. And I feel comfortable you can do this within 3 months, but I'm going to talk about that in a moment. But if your disclosures are done by October 9th, then we will say, stand by. That by January 8th, all discovery will be completed. So that brings me back to the question to you, Mr. Crossan. Well, hang on a second, let me ask another question. Mr. Barnett, do you anticipate the potential for dispositive motion?
I do.
Right? What did I say, January 8th will close discovery? All right, Mr. Crossan, do you anticipate the potential of filing dispositive motion? That is, a motion that would, that might demonstrate that there would be no need to have a hearing on one or more issues.
Example would be a summary judgment.
Yes, sir. It's not called a summary judgment in the AAA rules, but it would be essentially like a summary judgment.
Yes, I would like to reserve my right to do that as the case proceeds, please.
Okay, here's what we're going to do then. If discovery ends on January 8th, any request for dispositive motion, a request under Rule 33, I think it's 33 of the commercial rules, won't matter because we're going to do it whether it's 33 or 34. 34 under the commercial rules, or if we're using the consumer rules, it's 31B under the consumer rules, it's 34 under the commercial rules. The rule number doesn't matter because they both require the same thing, which is that a party must submit a request to file a dispositive motion. There's no dispositive motion as a matter of right, and the request to file a dispositive motion must explain why a dispositive motion will either dispose of or significantly narrow the issues in the case. So, with that in mind, the deadline for that is going to be 1/15 to request to file a dispositive motion. There'll be no reply to a request, there'll be no opposition to a request to file a dispositive. Well, I'm going to put a date in there because it sounds like you are going to agree. 122 will be a response, and that's all that's required about to determine whether there should be a dispositive motion. So 115 to request, 122 to oppose, and looking at the calendar here, I will tell you by 127 if anybody's authorized to file a dispositive motion, and at that time I will enter a schedule for dispositive motions. I want to tell both parties that whether it's the consumer rules or the commercial rules, dispositive motions are considerably less favored in the arbitration realm than they are in the district court, federal district court, or state district court. That's not to say they're not appropriate, and they may very well be appropriate in this case. I'm not prejudging that. But keep in mind that if we're going to have a hearing anyway, you're going to persuade me that a dispositive motion is appropriate. It's going to have to explain how it will significantly narrow the time that we need to spend in a hearing. So just, again, I know you don't know now, I certainly don't know now, but just think about that when January 15th rolls around. Am I really changing the nature of this case, or am I just getting rid of one little issue that can be resolved in the hearing? Because if we're going to enter a schedule for a hearing that will allow time for dispositive motions. So, you know, that we'll do that if we need to. All right. So if we don't know until... Yes, sir.
Mr. Helton, apologies.
Yes, sir.
Can I request a page limitation on those requests to like 3 pages or something like that?
Yeah. Page limitation of the request? That's going to be 2 pages. It does not argue your motion. What it's going to say is, what you're going to say is, and I was going to put that in, but I'm glad you asked about it. It's going to be 2 pages. what you're going to say is there is a legal issue that can be resolved simply by reference to the law or the agreement if they were still operating under that agreement. And I want to file a dispositive motion to explain that. Or there's a factual issue and discovery has revealed that there is no disputed fact on this issue or no material disputed fact. That's all you're going to say. And so if Mr. Barnett, Mr. Cross, if Mr. Barnett files something and says, Arizona law statute ABC 123 says this is not a claim that exists in the law, you're welcome to write back and say, I don't think there should be a dispositive motion because the case is saying that sometimes it is a claim. But that's all it's going to be. Right? Don't argue your motion. Understand, Mr. Crossett?
Yes, sir.
Okay, you understand, Mr. Barnett?
I do.
Okay. If we're going to do that, if I authorize a dispositive motion, I'll give you the schedule now. It's going to be, let's see, January 27th. If on January 27th I authorize you to file a dispositive motion, the moving party, whoever's authorized, is going to file by February 5th. Not to exceed 5 pages in length, exclusive of exhibits. The reply, AAA's schedule order says reply, but the opposition will be February 19th. And which will also be 5 pages, and a reply will be February 26th, not to exceed 3 pages. Remember, anybody who files a reply to anything, no new arguments, no new evidence, just commenting on whatever the opposition is. Okay. If there is a dispositive motion, and it's fully briefed, or they are fully briefed by 2/26, I will give you a ruling by 3/12. So by March 12th, we will know what, if anything, is left in the case for a hearing. So then, now maybe that's fleshed this out for you, Mr. Crossett. If by March 12th, we've closed discovery, we've resolved any dispositive motions, if any, when can you be ready to have a hearing? And I'm asking you first, Mr. Crossett, because you have the burden of proof right now.
What was the last date you had? March something?
I'm going to rule on any dispositive motions, if any, by March 12th.
I would be ready. Again, I've got to have some discovery. I can't go to a hearing when I don't know the facts. I have to have the facts. I certainly don't want to abuse the system in any way. I'm looking at maybe 5, 8 interrogatories, maybe a couple of production of documents, and I only want one deposition, and I've made that very clear that Toro can provide that individual that knows the facts of the case. If I have that information, I certainly would be ready by April 1st to go forward, please.
Well, you may have misheard me or not heard me, Mr. Crossett.
All right.
Discovery is going to close on January 8th. You'll have opportunity between October 9th and January 8th to do whatever discovery you need.
That would be fine.
We're past that.
Okay.
Okay. So again, if by March 12th I've resolved any dispositive motions, if any, how did you say you could do a hearing by April 1st?
Yes, please.
Okay. I'm going to. How long, Mr. Cross? How many days do you think you'll need for a hearing?
Well, I'm not sure how I can determine that because I don't have the information of what they did and how they did it. I'm going to, can I give you an estimate? Is that reasonable?
Please. Everything's an estimate. Yes, sir.
I'm going to say 1 to 7 days.
Okay. I'm going to, unless Mr. Barnett tells me he thinks it's going to be longer, I'm going to block 3 days. Mr. Barnett, do you have some reason to believe that a hearing will take more than 3 days?
I don't think it will take 3 days.
Okay, I'm gonna block 3 days, but we're gonna put 3 days in the scheduling order, but I'll tell both parties, I'm also gonna leave my 4th day available too, just in case. We wanna be sure everybody has an opportunity to do everything they need to do. So now, we're gonna take a look at that. I've actually gotta look at my substantive calendar. And Mr. Crossett, you have asked for an in-person hearing, is that correct?
Yes, please.
Okay, we will do an in-person hearing. And we will start an in-person hearing on April 6th.
I have a conflict. I have a conflict that day. Actually, can we look at a different day near there?
How about April 12th?
Let me look really quick.
I'm going to say April 13th if that week works for you.
Yeah, just one second. April 13th works great for me.
All right, we will start an in-person evidentiary hearing on April 13th at 9 a.m. Mountain Central Time, unless the country is stuck with daylight time by then. But it will be 9 a.m. of whatever the time zone in Mountain Time is at that time. That will be in my offices at 6550 South Mill Rock.
No,
Suite 200.
I'm sorry, no. I'm not going to meet in an attorney's office. I find that to be, you have a letter from my therapist. You'll have another one in the next 24 hours. I'd like to have, please, a neutral site.
That is a neutral site, because I'm the neutral. If you want to pay for another location, I'm offering the parties a free location. If there's going to be a location, I should have told you this all at the beginning. Anything you agree on that's legal, I'm going to agree. I'm not going to change anything you agree on that comports with the law. If you don't agree, then I have to make a decision. And I'm offering you a free location, but okay, let's get into this question. Mr. Barnett, Mr. Crossett does not wish to do this at my office. I'm amenable to anything you all agree on.
I think maybe just as a point of clarification, I'm not sure, David, if you understood that Mr. Helfand was offering his offices, not our offices. I don't know anything about his offices. I've never been there. I don't know the address. I don't know anything about it. But he is the neutral, and we would only agree to do something that's free and that has adequate facilities for us to be able to do it comfortably. You know, with be able to have places for witnesses and appropriate electronic setups and seating arrangements. So if you have another location in mind that's free, I'm willing to talk about it. But I thought that was a generous offer. I was going to offer to do it at our place if you wanted to do, but it sounds like you're uncomfortable doing it at our place, so that's fine. We don't need to do it here.
So, Mr. Crossett, again, if you and Mr. Barnett, here's what I'm going to do. I'm going to schedule it in my office. And the reason I'm going to do that, Mr. Crossett, is one, it's a neutral location. Two, the conference room in which we're going to do it is immediately accessible from walking in the front door of the office. So you won't be around any lawyers other than the lawyers in this case, and I happen to be a lawyer. You won't be enmeshed in any of the legal practice of the law office. There will be an office available for you adjacent to the arbitration room where you can sit with any witnesses, with any assistants that you have, and confer confidentially. And to Mr. Barnett's point, it has all of the ability to look at things on a big screen. It has the ability to allow you to look at things to the extent that you're able to look at anything, or use computers that can connect all that thing. So here's what I'm going to do, okay? I'm going to set it in my office. I'm going to leave it to you, Mr. Crossett, and Mr. Barnett, and Ms. Merrill, if you all want to talk about a different location. But you're going to have to come to an agreement on that location
Well, let me see if we can do a shortcut. I've checked the Bountiful City Hall. It is 100% accessible. Their rooms are very, very large. They're very, very cheap. I'll pay for it myself. I'll pay for it myself. I'd like to have it at the Bountiful City Hall, please, because it's wheelchair accessible and it's neutral. To me, it's neutral. I don't want it in a law office, please. And my counselor has clearly indicated that's inappropriate for me.
Okay, well, Mr. Barnett, I don't mind going to Bountiful. If Mr. Crossett is going to pay, is there any reason we can't use the Bountiful City Hall?
Well, I mean, I guess I'd like to visit further with Mr. Crossett about this, and we can maybe come back to you if we're not able to agree. I'd like to visit the facilities or have someone visit the facilities to see if they're adequate for our needs. And I appreciate his offer to pay for it. I'm sensitive to the fact that there may be additional costs associated with your time. And if we proceed under the commercial arbitration rules, I'm slightly less worried about that if I'm splitting your costs with Mr. Crossett. But if the burden of your fees are all upon Turo, and there's additional cost associated with your travel to Bountiful and the inconvenience of not being able to have your office, all the things that would be available to you in your office, I'd like to think about that. So I'd like to, Mr. Crossett and I can visit offline about this, and if we're not able to agree, maybe come back to you.
I think that's what we'll do. So I'll set it in my office. You all can reach an agreement. If it continues to be a point of contention, then I'm going to address how we normally resolve any disputes in just a moment. So that's where I'm going to set it. Each party will have, since we're allotting 3 days, we'll have 7 hours to present testimony, as well as submit exhibits and make any argument that they wish to make. Okay.
Can I clarify one quick thing? You mentioned to Mr. Crossett that if we were in your office, that he would have a little bit of confidential space for him and anybody else that's associated with him. Would that also be something that would be available to us in your office, I'm trusting?
Of course. Yeah, no, the idea is each party would have, there's room for witnesses to wait to testify. There's conference rooms for each party to work with their respective representatives and anybody they need to talk to.
What floor is that located on?
It's on the second floor.
Is it wheelchair accessible?
Yes, sir. There's wheelchair accessible parking. There's an elevator and wheelchair accessible entrances to all of them. It's a relatively new building. Look, I think Mr. Barnett, we need to keep moving forward. Mr. Barnett has presented a workable way of addressing this problem. I'm going to set it in my firm's offices. It provides everything we need for a hearing. If you want to work together to pick a different location, I will go wherever you all agree to do it. And if you don't reach an agreement, then I'm going to tell you how we're going to deal with anything where we don't have an agreement in just a moment. But what we're going to do about it right now is, if we're going to start the hearing, as we said, on April 13th, then hold on 1 second here, let me get the calendar back up. By April 5th, you are going to serve and file a disclosure of witnesses you anticipate testifying at the hearing. No person who is not disclosed will be permitted to testify unless there is good cause shown. You're going to send each other, and you're going to file in the web file system the list of witnesses. It's the full name, their address, their email address, and their phone number, as well as a general summary of what they're going to say. All right, understand that, Mr. Crossett?
Yes, I do. Thank you.
Great. Understand that, Mr. Barnett?
Yes.
Okay. Also on April 5th, you're going to submit your hearing exhibits. Now, here's what we're going to do with hearing exhibits. This is in the, Mr. Crossett, if you have an opportunity to have the system read back the scheduling order when you receive it, you'll get this read to you. You're going to work together in advance of April 5th. You all pick the schedule. But by April 5th, you're going to know what exhibits you both agree are appropriate for the case. And you should strive to agree to the documents that are relevant to a claim or defense in the case. And you'll make those joint exhibits. And just, again, let me encourage you to agree as much as possible on which exhibits are relevant to the case. Understand that the opposition to the admissibility of an agreement should not be because you don't like what the agreement says. It should be based upon you have a good faith argument of why it's not relevant to a claim or defense in the case. And keep in mind that in arbitration, the arbitrator will consider things that may not necessarily be appropriate in a trial under state or federal rules of evidence. But I also understand enough about evidence to give evidence the weight that it deserves. So work together to identify joint exhibits. You'll file joint exhibits as marked as J1 through J whatever. And you'll submit those on April 5th. As to any document or thing that you believe should be in the case that is not the subject of an agreement for a joint exhibit, Mr. Crossett, you'll mark those as claimant 1 through claimant whatever. Mr. Barnett, you'll mark those as respondent 1 through respondent whatever. Do not mark a joint exhibit as one of your exhibits. Don't duplicate as one of your exhibits an exhibit that's a joint exhibit. Joint exhibits I will admit all joint exhibits at the very beginning of the hearing before hearing any evidence in the case because you all agreed to them and they will be a part of the record in the case. Any agreement that is not a joint exhibit will need to come up in the presentation of the claimant's or the respondent's case. And if there's an objection, if there's no objection, then it will be admitted. If there is an objection, then we'll hear what the objection is and I'll decide whether it should or should not be admitted and if it's going to be admitted for a limited purpose, what that limited purpose may be. Mr. Crossett, do you understand what we're doing with exhibits?
Yes, sir.
Okay. Mr. Barnett, understand what we're doing with exhibits?
Yes.
Super. All right. That'll all be done by April 5th. Is there a basis for a claim for attorney's fees in this case, not by Mr. Crossett, because Mr. Crossett, you're not represented by an attorney, is that right?
That is correct. But I do have consequential damages and other damages, but attorney fees, I'm under the impression that I cannot receive attorney fees because I'm not an attorney.
I think everybody would agree with that. So now on to Mr. Barnett. Mr. Barnett, is Truro going to have a claim for attorney's fees in this case?
With apologies, I'm going to need to get back to you on that.
Okay. Well, here's what we're going to do. Okay? I'm going to set some deadlines, and if they become moot, then they become moot. Okay? If Truro is going to claim attorney's fees, one thing you need to do is what was the deadline for specification of claims? By August 5th, you're going to need to file a counterclaim. For attorney's fees. You follow me so far, Mr. Barnett?
Yes.
Okay. By the way, if there's any, after when Mr. Cross is going to specify his claims by August 5th, Turo is going to file any response to that by August 19th. Mr. Crossett, if Mr. Barnett or Ms. Merrill for Turo identifies a counterclaim for attorney's fees, you're going to respond to that by August 9th. You could just file something that says, here's why I don't think attorney's fees are appropriate. By the way, under the rules, if you don't file anything at all, you'll be deemed to just be denying the availability of whatever the other parties claim. There's not going to be a default because you didn't respond and explain that you don't agree attorney's fees are appropriate. But if there is a claim for attorney's fees, then Mr. Barnett, well, here's what we're going to do. I think we'll do it this way. Yeah, this is what we're going to do. If there's a claim for attorney's fees, by April 5th, Mr. Barnett, you need to tell Mr. Crossett what you believe were the reasonable and necessary attorney's fees up to that date, and your reasonable estimate of additional attorney's fees through the end of the hearing by April 5th. Mr. Crossett, if Mr. Barnett gives you, for example, billing records that show the amount of time, if there's a claim for attorney's fees, it shows you the amount of time that his firm has billed and anticipates billing Turo for their work, and the rates that he's using, you need to respond to Mr. Barnett by April 12th and tell him whether you agree, even though you don't agree that he's entitled to attorney's fees, you agree those are reasonable and necessary fees incurred by Turo. That's not a decision of whether attorney's fees are recoverable. That's an agreement on whether what the attorney's fees were and will be are a reasonable amount of time times a reasonable local rate in the Salt Lake City area. Do you understand what you're going to do, Mr. Crossett?
I do understand exactly what you're saying, and I think it's important to be on the record that I've also received a waiver of fees on the commercial side of what's going on. So how attorney fees tie into that waiver of fees, I'm not sure what the rules and regulations are.